Stephen Kinnock.
Thank you very much, Chair, and many thanks for coming today to speak with us. I wanted to ask about the Withdrawal Agreement Bill, but just before I do that, I just wanted to go back on one point around the constitution of the European Parliament in the context of a possible extension. We've talked, of course, about the risks of litigation, but there's another, of course, very important function that the European Parliament will have over the course of the summer, which is the nomination and confirmation of the President of the European Commission and of his or her team of commissioners, which will be done, first of all, for the President on the basis of the Spitzenkandidat system, and then there'll be each of the European Parliament committees will have hearings to confirm each of the candidates for each of the commissioner posts. What is your assessment of the integrity of that system if the United Kingdom is still a member state when those hearings are going on, but we haven't taken part in European parliamentary elections?
I think you're right that it would question the integrity of that particular process, but you're going to have to think about it again in terms of how long the extension is and how that links into the particular process and whether we've been in a situation where we've been able to negotiate a protocol. So the shorter the extension, if there was an ability to go away and raise this and negotiate a protocol for us to have some kind of say that relates into how long we'll be continuing the membership and what our role would be. So then I think you can then shore up the integrity that way. If you're dealing with a longer extension, then obviously it will, I think in that scenario, you'd have to move to holding elections because we'd be going beyond the 2nd of July and then having the integrity of the process that way, because we'd obviously gone through the election process and have members.
In the context of the proposal for a possible second referendum, the Institute for Government has said it would take a minimum of 25 weeks to organise and hold a referendum. So that would actually be in direct parallel with the period in which the European Parliament would be nominating and confirming the new European Commission. So if specifically for a request for an extension to hold a referendum, we think that's a minimum 25 weeks. That would inevitably, therefore, be at the same time as the European Parliament is going through this process with the new Commission. So in that scenario, your view is that the integrity of that process would be fundamentally undermined if the United Kingdom is still a member state, but we haven't participated in the European Parliament elections.
I think it's important to recognise what I mean by undermining the integrity there. I'm thinking of it in terms of background constitutional principles. It's much more complex in terms of the ins and outs of what the precise legal situation would be, because obviously this is a novel scenario and it would require interpretation. But in terms of upholding good constitutional values, you're in a very difficult position if you are requiring, on the one hand, the member state is still a full member of the European Union pending leaving, but on the other hand is not in a position where it can take part in those decisions, which is why I think you'd have to have very complex and difficult negotiations to uphold the integrity of that process, yes.
So it's not just about the Parliament as an institution, it's all about the European Commission.
Absolutely.
And that would be a massive issue, of course, for the
absolutely.
EU. Moving on to the Withdrawal Agreement Bill, could you just give us a sense of the constitutional and legal and political significance of the Withdrawal Agreement Bill? Because it seems to me that it is of massive and fundamental significance, and yet, here we are without even having a draft of it to look at. So it would just be good, I think, if you could give the committee a sense of how important that piece of legislation is.
I will try my best. Obviously, I've already mentioned earlier the requirement under the withdrawal agreement to ensure that European Union law and the provisions of the agreement continue to have the same force, which means they still have to have direct effect and they still have to be able to disapply contradictory legislation during the implementation period. Obviously, that is going to require careful wording to ensure that we do have that particular constitutional effect. the precise wording will then interact with the potential of other provisions that could be potentially entrenched in this particular manner. It's not just in terms of maintaining the wording, but you also have provisions, so for example, the lifetime commitment to citizenship, rights of individuals who have started to commence citizenship rights during the implementation period. We already have a mention in the white paper that was produced when it was known as the implementation bill, that this would require in some way, shape or form special procedural requirements in order to be able to protect these particular guarantees. It's not just with regard to the lifetime citizenship rights. You also have non-regression clauses in the withdrawal agreement to maintain various standards. So, for example, environmental law and labour law rights. All of those are going to be very difficult to ensure you succeed in a way that satisfies the requirements of the withdrawal agreement and that satisfies the European Union that have effectively implemented the withdrawal agreement in a manner that is carefully negotiated in terms of its impact on parliamentary sovereignty, if we're including special procedures that would need to be used in order to remove these rights. This is a hugely controversial, contentious issue in constitutional law, which would require very careful wording, not just in terms of how you set out the legislation, but also in terms of how the courts would then interpret that legislation specifically and also with regard to other areas of the law. So it has huge knock-on constitutional ramifications. You also then have to look at aspects, for example, how far you would want to have parliamentary scrutiny over the joint committee, whether how far you would need perhaps legislation or further discussions as to how you would deal with scrutiny over joint committee decisions. And you'd also have to think very carefully about the interactions between the European Union Withdrawal Agreement and the European Union Withdrawal Agreement Bill, because there are differences in terms of, for example, not just aspects of the law. So the European Union Withdrawal Act, as it stands, would remove the Charter from exit day, which would be incompatible with the withdrawal agreement, which would require the retention of the Charter during the implementation period. That's not obviously yet enforced, but you'd have to make sure that was carefully negotiated, and you'd also have to ensure the continuing role for the European Court of Justice within the withdrawal agreement, which is not currently in the European Union Withdrawal Act. So you have quite large constitutional ramifications, not just in order to ensure that we satisfy the requirements of the withdrawal agreement so we implement it correctly, but also this is going to require us to think very carefully about parliamentary sovereignty.
Would you say then, given what you've said there, that the fact that the government has not yet published a draft of this bill is a constitutional outrage?
You're giving I would go to the phrase, I'm very severely constitutionally concerned as a constitutional lawyer.
Very severely constitutionally concerned.
It's a new phrase. I'm not sure if that's an outrage or not, but I'm very concerned.
And one final point really is just around specifically Article 4. Mm-hmm. Yes. It is the case that Article 4 gives supremacy to EU law
during the implementation. That's right.
During the implementation period. Mm-hmm. Is that something that you predict would be politically contentious if Parliament were given the chance to debate and vote on that particular issue of the Withdrawal Agreement Bill?
It obviously will raise political concerns because of not just in terms of with regard to continuing the role of European Union as per withdrawal agreement during the implementation period, but also because within the withdrawal agreement terms, you're in a situation in which the legislation that would be enacted by the European Union during the implementation period, if we don't have the political rights, so we don't have the say in that law, but at the same time the withdrawal agreement during the implementation period would require us to give primacy and direct effect to that law, which is obviously a very different position from current membership of the European Union, where we do have that political say in the enactment of the law that then has direct effect and can override disapply legislation.
Thank you very much. Thanks, Chair.